Welcome to Kanooni CHARCHA. Today I am going to discuss section 195 of Code of Criminal Procedure and its corresponding provision you will find in section 215 of BNSS Bharatiya Nagrik Suraksha Sanhita 2023. This section relates to the offences. I will read first the heading of this section. Section 195. This is a Code of Criminal Procedure. Prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to document given in evidence. Today I will touch this part of the section heading for offences relating to document given in evidence and a relevant judgment. Recent in time, this is a judgment on, it is dated 10th of September 2024, having titled, I will Aroisami versus State of Tamil Nadu. It is a judgment of two bench. There were judges on of this bench, this two bench. Justice Hrishikesh Roy. And this judgment is authored by Justice Hrishikesh Roy, and with him Justice R. Mahadevan was in the bench. Now I will go read out the relevant portion, which is touching to this judgment, and which is relevant to the present episode. Now I will read out. I have read this heading. Now there is a bar, specific bar. No court shall take cognizance. What is? Obviously, when court cannot take cognizance, no complaint, no charge sheet can be filed by the by way of complaint or police charge sheet before without fulfilling the following condition. This section A is related to this prosecution for contempt of lawful authority of public servants. I am not touching that. I am touching the relevant, which is relevant to this judgment, the subsection 1, B part of subsection 1, and this Roman 2nd. I will read out now. Of an offence, देखिए no court shall take cognizance. I will get directly to the relevant subsection. Of any offence described in section 463. This is framing of a false document. This is forgery of a document, or punishable under section 471, section 475, or section 476. These are the offences. The cognizance of the court cannot be taken by a court without having the compliance of the following. Now I will come. Then such offences alleged to have been committed in respect of a document produced or given in evidence in a proceeding in any court are. This is when. Now this section which bar is created for filing of a direct complaint or police FIR before a police, only in that cases where the document is in the court and when an offence is committed with regard to that during the currency of the proceedings. It may be a civil court proceeding, it may be a criminal proceeding, any of the, even this proceeding before a revenue court. This is the definition of court. You will find in this section that it is provided that this I will read out para subsection in order to clear the proceedings where the court term court how it is defined. In clause B of subsection 1 of the term court means a civil court. Just say I have already verbal made the verbal version, verbal commands with regard to this subsection means a civil, revenue or criminal court and indicates a tribunal constituted by or under a central, provincial or state act if defined by that act to be court for the purpose of this. Court may be a court of this law, it's a civil court, it is a criminal court or a tribunal. This is a definition of a court. No court take cognizance. This is related to that. Now let me come to this judgment. I am here to delve upon the what was a matter. This is a Aroisami versus state of Tamil Nadu. I have already mentioned this heading of the case. What this is a criminal appeal before the code of this Supreme Court of India, and earlier the matter was before this High Court for quashing of the criminal proceedings initiated by a court. Initiated by a court, obviously, for forgery. I will read out this right. Now, what the order, but I will again explain the order of the High Court. There the prayer was made for quashing of the proceedings was accepted, and this proceedings was quashed before a trial court, criminal court proceeding of forgery. Then that was quashed by the High Court. Against that order, now I will read the relevant para, which is very. The state was also arrayed as a party in this case, and state has supported the appellant that the proceedings undertaken by a trial court for committing of forgery is valid in law. This is sustainable, but High Court has quashed the criminal proceeding. Against that order, the Supreme Court was approached by the complainant, obviously by the complainant. Now, para 6 is relevant. The learned counsel for the respondent, on the other hand, would submit that no doubt the concerned civil court were disposed of on 19 civil suits were disposed of on 9th of April 2021 by the learned subordinate Satyam Mangalam, but aggrieved party then preferred appeal, and those are pending. Now I will discuss this para afterwards, but now come to para 7. The above would indicate that the High Court proceed on a wrong assumption. This is the finding observation of the Supreme Court with regard to with regard to this case, with regard to this criminal appeal, that civil litigation between the parties had not attained finality. That apart, in our considered opinion, the High Court has heard in questioning the proceeding by holding that there can be no FIR, private complaint for forgery of a document filed before a civil court until the finality of the litigation. What is the High Court's contention? Why High Court quashed the trial court's this criminal proceedings? It initiated this by way of a complaint on the ground that the document which was produced in a civil suit, that civil litigation has not attained the finality, and there is a bar of section 195 of Code of Criminal Procedure, which I have read earlier, that no court take cognizance with regard to forgery, but that is related to the when forgery is committed during the proceedings of a before a civil, criminal, and revenue court, or I have read out the definition of the court earlier. Now I will further read by this the how the observation the order was found illegal, bad by the Supreme Court of India in this criminal appeal. I have read the High Court ignored the ratio of Constitutional Bench. The Constitutional Bench has already decided this point that no VAR is applicable in a case where the document is already forged. It is only produced before the court in a civil or this civil litigation in the present case. Then if already forged, and then a court can take cognizance, and this police can be approached by way of lodging of FIR with regard to committing forgery. I will read out further. But Constitutional Bench has held, this is a Constitutional Bench judgment is titled Iqbal Singh Marwah and another versus Meenakshi Marwah and another reported in. This is a case of Supreme Court of 2005. Now, but has held in that judgment, wherein it has been held that there is no embargo, no restriction, no prohibition, no rider under section 1951B second of Code of Criminal Procedure to examine the criminal allegation of forgery of document filed in the court when such forgery is committed before its production in the court. The forgery is already made by the whosoever is wronged. The before the production of that, the forged document, forgery is offense of forgery is already completed, committed, and this forged document is produced after committing a forgery. It is not committed in the court proceeding. If the forgery is committed and forged document is acted upon in the course of the proceedings of a criminal or civil or revenue court, then section 195 came into operation. Now I will read further. When such forgery examined before its production, the relevant extract are already produced here. Now the relevant para of this Constitutional Bench 25 and 33 is there. My viewers would read it, and otherwise this episode will go long. Now I will come to para 8. These two paras have been appreciated, considered by the Hon'ble High Court, and drawn their finding in para 8. In the present case, the allegation in the complaint is that respondent had fraudulently obtained a stamp paper. The complaint, criminal proceeding on the basis of which is taken by a criminal court. What was the allegations? The allegation in the complaint is that the respondent had fraudulently obtained stamp paper and prepared an unregistered sale agreement. Thereafter, suit was filed by respondent seeking certain relief in the suit. The forged document was filed. Meaning the document was already filed and forged, and that document was produced in a suit. The allegation do not indicate that document was forged when the matter was sub judice before the civil court, but the forgery has already committed, not during the course of a civil litigation, civil suit. This is observation of the Hon'ble Supreme Court of India by taking assistance of Constitutional Bench judgment Iqbal Singh. I have referred here, referred in para 7 of this judgment. Now, accordingly, as per ratio in Iqbal Singh case. So, for this, the bar under section 1951B second of Code of Criminal Procedure is not attractive. The complainant, whosoever is aggrieved by the forged document and its production before a court in a suit, If he is aggrieved, he can file the complaint. There is no bar. He can even go to the before the police for registration of FIR. There is no bar because forgery is committed not during the course of. If that has been committed, the cognizance, this criminal complaint proceedings would have been filed by the code itself on finding that it has been forgery has been committed in the course of the proceedings before him. But in the present case, forgery has already been committed and document forgery is produced in the suit. Now, is not attacked following the above, means following the judgment of Constitutional Bench of Iqbal Singh and noticing the apparent error in foundation of the impugned order of the High Court dated 6th of October 2022. The same is set aside and quashed. The earlier the complaint proceeding criminal was quashed by the High Court. Now, by the High Court, this order of quashing, impugned order before in criminal appeal before the Supreme Court of High Court was quashed. The appeals are allowed. This criminal appeal was allowed. It is ordered accordingly. Before parting, means with the setting aside of High Court's order, which has quashed the criminal proceeding, the criminal proceedings complaint and its proceeding becomes operative. Now, before parting, it is made. This is a observation made that present order is only in the context of impugned order of the High Court dated 6th of October 2020, and we have not pronounced on merit of pending case of either party. Means there was a suit pending that was disposed of earlier and its appeal was pending. The bench has made it clear that it is only related to this order. This order is only related to the order impugned in the criminal appeal before them, and has we have not touched either this appeal, civil appeal pending before the appellate court obviously, and the criminal merits of the criminal proceeding that would be decided by the court concerned. Now, in short, crux of this judgment and this relevant provision we have discussed of 195 1B second of Code of Criminal Procedure, corresponding provision of section is you will find in section 215 of BNSS. In short, is that if a document is forged and is produced in a criminal in any proceeding before any court, that may be a proceeding of a civil nature, is of a revenue matter, or it may be a criminal proceeding. If some forged document is produced, then the complainant, whosoever is aggrieved by way of the forgery of the document, he can approach for initiating the criminal proceeding regarding forgery of the document. He can approach the police or by way of a complaint in a criminal court. But I will further explain. The bar is created. This no court take cognizance under this section 195 of Code of is related to that if some forgery is committed, offense of forgery is committed. The sections I have already 463, 4719 and 475. Now, if these offences are committed in the course of the proceedings before a court, then it is the court, the court who has to lodge the complaint or any criminal proceedings. But when offense is committed, this word is when. You will find the word this when in this provision, specific provision is there. When I will read out again. Of any offence described in section 463 or punishable under section 471 section 475 or section 476. This is no court shall take cognizance with regard to these offences, or these offences are related to offence of forgery. When such offence is alleged, when, word is when such offence is alleged to have been committed in respect of a document produced and given in evidence in a proceeding in any court. If forgery is committed, offence of forgery is committed in the course of this proceeding before a court, then that court has to lodge the complaint or can initiate the criminal proceeding. If already there is a forgery of a document, and before its production before a court, then the concerned party who is aggrieved of this forgery, he can approach and get initiate the criminal proceeding. This is the crux of judgment, and so the trial court where the complaint was, he allows the taking of criminal proceeding after filing of a complaint as it appears from the facts of this case. But High Court quashed the criminal proceeding initiated, and this order of the High Court was assailed in Supreme Criminal and Criminal Appeal. Hon'ble Supreme Court of India quashed the order of this Hon'ble High Court and held, I will repeat again, that the court proceedings, criminal proceedings can be initiated relating to forgery when it has the forgery has committed, document is forged. In the present, this document has already been prepared. That is a document. In the present case, the document was with regard to production of this document was had fraudulently obtained. You see, I will read out para 8 relevant to this. Again, I will read. In the present case, the allegation in the complaint is that the respondent had fraudulently obtained such stamp paper and prepared an unregistered sale document. It means that offence of forgery has already been committed, and forged document is prepared. That has been produced before this in a civil suit by the obviously accused party. Aggrieved party can take criminal proceeding for forgery in a competent court of law. This is the crux of the judgment. I think this is sufficient part today. Thank you very much.